102 and 103 mark.
Thank you.
Sir, would you state your full name, spell your last name, please?
Nicholas Kirk, last name's K-I-R-K.
Thank you. Mr. Atwell.
What's your occupation?
I'm a police sergeant for the city of Livingston.
How long have you been in a sergeant?
A sergeant for about a month,
How long have you been working for the city of Livingston?
for almost 15 years.
And have you been an officer for the entire time?
Yes.
What training do you have as an officer?
Various trainings. Do you have anything specific or?
Did you, what kind of police academy did you go to?
I went to the Stanislaus County Sheriff's Regional Training Center in Modesto, California.
In your career, how many cases have you handled?
I mean, hundreds, if not maybe 1,000 of them.
And approximately how many thefts have you handled?
Hundreds.
Were you still working at the Livingston Police Department in September of 2021?
Yes.
And were you on duty on September 28, 2021?
Yes.
Did you respond when you were forced on that day?
I responded to the Foster Farms plant, Livingston, for some protesters that were in the area.
What did you find when you arrived at the scene? Did you go to the facility?
Yes.
What did you find when you arrived?
There were several people associated with a group that had a U-Haul truck that were blocking the truck entrance to the plant. There were several others along the sidewalk and roadway as well.
What were they obstructing? What did you find they were obstructing?
Objection, Your Honor, that calls for hearsay. This witness was not there at the time.
Objection overruled.
They were obstructing the ingress and egress of the trucks that were bringing in poultry to the.
Did you get any report regarding any of these trucks?
Yes.
What was reported?
I was notified by security that there was a theft of some.
Objection, hearsay.
Sustained.
Let me rephrase. Did you conduct any investigation regarding the trucks?
Just to clarify, we're talking about the Foster Farms trucks.
Yes.
Yes, I did.
What were you investigating?
I was investigating theft of some chickens.
In the course of your investigation, and what, how did you investigate?
I spoke to the reporting party, who provided the information.
After you spoke with the reporting party, what did you do?
I later completed a police report regarding the matter, but I had also done some research on the matter, found several pieces of, I guess, evidence, you could say.
Was the reporting party at Foster Farms employee?
Yes, it was.
What media did you find?
I found several pieces.
Your Honor, I'm going to object. This calls for hearsay.
Not in,
Well, the objections are all ruled for now, but we'll see.
all right. And was there any in particular piece of media that you found?
Yes.
What was that piece of media?
I found a news article from the Merced Sun-Star as well as a YouTube video posted.
What did the YouTube video appear to contain?
Objection, Your Honor.
Yeah,
That's hearsay.
hearsay.
Sustained.
Permission to approach the witness, Installate Foundation.
You may.
It was People's 101 request to put it on the screen.
Yeah, you may publish. It says been admitted.
Do you recognize the image behind you?
I do.
Or was it?
Appears to be the YouTube video that I viewed.
I'm playing People's 101. Is this a fair and accurate representation of the video you saw?
It appears to be it.
People are playing People's 101.
I got it, Alicia, I got it, go.
Sure.
We got it, we got it, we got it.
Was that the YouTube video you watched?
Yes.
Can you please just briefly describe what happened?
Two females were seen running up to a Foster Farms truck that contained poultry, and the females then opened up the, I guess, cages above the truck and removed a chicken each before running back to their vehicle and getting inside.
People are going to be moving in, people, 1, 2, people have paused People's 101 at 13 seconds. Do you see a woman's face in this image?
I do.
Do you see this woman in the courtroom today?
I do.
Where is she?
She's to my right wearing a black blouse and black shirt.
The witness has identified the defendant, Alicia Santurio.
People are moving forward. People have paused at 16 seconds in. Do you see the face of a woman in this image?
I do.
The witness has identified. Oh, I'm sorry, go ahead.
Do you see the woman is there a woman on the right?
Yes,
Do you see that woman in court today?
I do.
Where is she and what is an article of her clothing?
She's also sitting to my right wearing a white shirt and a blue blazer jacket.
The witness has identified defendant, Ms. Alexandra Paul.
play it any from the start again? Approximately how, no, and people will pause at 8 seconds. Approximately how far do you think the defendants ran there? Now that the woman in the video ran.
I'd say approximately 30 to 50 feet maybe.
People are, so want to continue replying for comments? People will pause at 10 seconds. Do you see any chickens in this image?
Yes.
And do you see a square what obstructions do you see for this lowest cage in this image?
Obstructions?
What, if anything, in this image is blocking the side of that lowest cage?
Looks to be maybe a piece of metal or something, I believe.
Move to strike, Your Honor. That's speculation on the part of the witness.
Well, Mr. Atwell, you're gonna have to be more specific, I suppose. It's loaded.
Let me go back. Can you clearly see all of the chickens in the cage from this angle?
No.
Rewinding the video back to 6 and playing it. In that brief scene, did it look like the woman did they stop to look into the cage?
Your Honor, I'm going to object. This is asking a witness to comment on evidence outside of his personal knowledge.
Sustained. The video can speak for itself.
Understood. Where did you, no, who posted the video?
I don't recall specifically who posted the video, but
you mentioned a article. Did the article provide? From everything you've seen in court, do you have any doubt in your, and after reviewing the video, do you have any doubt in the mind that the people who took the chickens are the defendants here in courtroom?
Objection, Your Honor. That calls for speculation, commenting on the evidence.
Overruled.
I do believe it is them, yes.
No further questions for this witness?
All right, Mr. Little or Mr. Coward?
Thank you, Your Honor. Officer Kurt Goodman.
I'm not
Based
sure
on
you're
your-
gonna be recorded. Let's see, you have a wireless microphone?
Good morning, sir.
Good morning.
Your investigation identified Ms. Santurio and Ms. Paul as the two people who took the chickens.
Yes,
And you obviously were investigating and you determined that 2 chickens were taken.
yes,
And you know from where they were taken, from a Foster Farms facility in Livingston, correct? Well, a truck
Yes.
near that facility,
Yes.
correct? Did you ever have an opportunity to speak with either Ms. Santurio or Ms. Paul regarding this incident?
I did not.
So, to the extent that they had reasons for doing what they did, you don't know.
I do not know.
So you can help us answer the why question in this case, can you?
No.
With respect to this incident, it sounds like that you spoke with the truck driver, Eligio Hernandez, correct?
Yes,
And he was able to confirm for you that the 2 chickens were taken, correct?
correct, yes.
He also was not able to answer the why question, was he?
That is correct.
You also spoke with an individual from Foster Farms who further confirmed that 2 chickens had been taken, correct?
Yes,
But he obviously wasn't able to tell you what the 2 defendants were thinking or what their reasons were.
no, he was not.
Now, I know you said on direct examination that you don't know who specifically posted the video, but is it at least your general understanding that the video was posted by persons associated with the defendants?
Yes, I don't know if it was specifically from their group or a, specific person, I don't recall that.
So this is not a case where, at least based on your investigation, the 2 defendants were attempting to conceal their behavior, correct?
Objection, Your Honor, speculation.
Oh,
No, it did not appear so.
That's all I have, sir. Thank you.
Officer Kirk, you prefer Officer Kirk, Mr. Kirk?
let's move the mic back.
Whatever, that's fine, I'm comfortable with anything, so.
Officer Kirk, I am counsel for Alexandra Paul and the defendants. I'm going to ask you a few follow-up questions. From your prior testimony, it sounds like you were responsible for an investigation regarding incidents that occurred at Foster Farms on September 20, 2021, correct?
Correct.
And that included collecting evidence of statements defendants made.
I'm sorry, the defendants made?
Defendants or affiliated parties might have made about the incidents?
For those that were there that I spoke to, yes.
And to see if there was any evidence that the crimes committed met the burden of proof that the state would have to prove in a criminal case, correct?
Objection calls for a legal conclusion.
Sustain.
I'm just asking whether you're responsible for collecting evidence that the prosecution used in a criminal trial like this, correct?
Yes,
And that would include all the elements of a theft. You would have to make sure you covered all your bases and got all the evidence they would need to prove beyond a reasonable doubt all the elements of theft.
Same objection, Your Honor.
Sustain.
Officer Kirk, you were responsible for obtaining evidence in this case, and that would include evidence of the value of the property at issue, correct?
that is correct.
And in fact, you did make an assessment of the value of the property at issue?
I was provided that information, yes, from an employee there.
And just to be clear, the property in this case was 2 chickens.
Correct.
And based on your investigation, you believe these chickens had some value?
Yes, that's what was relayed to me by the company.
Your Honor, I would move to strike. That's hearsay in response.
Well, the objections are objection, the objections are ruled, it was solicited.
I'm going to, Your Honor, I'm going to just take a moment to confer with co-counsel. approach the witness with the document?
You may.
Just the police report. Just to familiarize yourself with the document. You ready? Okay. Are you familiar with this document?
Yes.
And is this a police report you filed about the incident on September 28, 2021?
It is.
And I want to direct you to,
Cheryl, we're gonna take a lunch recess at this point. Ladies and gentlemen, we're gonna take a lunch recess. Just remember my admonitions, not to form your opinions at this point, not to conduct any investigation, talk among yourselves, or talk to anybody about this case. Mr. Alexandra Paul and Alicia Santurio, counsel and defendant. Defendants are present, all 12 jurors, regular jurors present, 2 alternates are present. And the officer clerk is still on the stand. Mr. Hsiung, you may continue with your cross-examination.
thank you, Your Honor. And you still do have the document, or?
Yes.
First, let me just apologize. I think I should be referring to Sergeant Clerk, the counsel
Yeah, that's fine.
corrected me, and you did testify earlier that you're a sergeant. No,
No worries.
just many apologies for that. Did not mean any disrespect. I think we were talking about your investigation of the value of the chickens when we closed the morning session. And you do believe these chickens, 2 chickens had some value, correct?
Yes.
You do believe it, okay. And we can probably agree that value is based on facts, not just based on an opinion made up out of thin air. There have to be some facts to back it up, correct?
Yes.
So if someone said one value one day and then said a value twice as much the next day and 100 times more the next day, that would suggest that it's made up out of thin air. Agree with that?
Values change all the time, so I can't necessarily say that.
Sure. But if it's the same exact item at the same exact time, and they're saying, oh, today the chair is worth $100, and tomorrow they say, actually the chair was worth $500, and the next day they say the chair is worth $10,000, would you agree those inconsistent statements suggest maybe that opinion is made up out of thin air? It's not as credible as an opinion based on facts.
I could say that, yeah.
Okay, good. We're in agreement there. But you didn't do that in this case, correct? In this case, the only report that you've issued indicates the chickens were $20 each. Is that correct?
That's what I was told, yes.
Okay. And you filed a report indicating each chicken was worth $20 each.
Correct.
And that's the report I just handed you.
Correct.
So Chris, $20 bill cumulatively between these 2 chickens. The information you have is these chickens are cumulatively worth $40 in total. Just doing the math. If there's 2 chickens, $20 each.
Yes.
And that $20 figure, you didn't change the number in any further reports, correct?
No.
It was always $40 for the 2 chickens.
Yes. That was the only dollar amount given to me by Officer Farms, yes.
In other words, that was information based on Foster Farms. They gave that number to you.
Correct.
Okay. And they didn't give you any other number, did they?
No.
So again, $20 each, $40 total. That was your report. That's the number you're sticking with. And you believe that number is accurate.
That was the number given to me by Foster Farms. I can't dictate what somebody values their property at. That's for them to dictate or specify.
But it can't be completely arbitrary. If somebody told you a piece of land was worth $1 million, you wouldn't believe them, would you?
You're correct, yes. Correct, yeah.
Great. We could probably agree that it would be a concern for everyone in this courtroom, including the jurors, if there was any bias for Foster Farms in the criminal investigation, right?
Objection, speculation, argumentative.
Sustained.
Do you think there was any bias for Foster Farms in this investigation?
Objection, speculation.
Sustained.
Do you personally have any bias for Foster Farms in undergoing the investigation of what unfolded on September 28th, 2021?
No.
No bias, okay. And would you agree that one form of bias would be, for example, pursuing charges against critics of the company because of their speech activity?
Objection, Your Honor, sidebar.
So, whether
for the fact that the jury is prepared to assist for that witness. And if this witness has some bias against the defendant, some profiles of crime, I think that's a perfectly standard for any sort of impeachment. He says it is. I will continue to focus on just this witness's personal investigation. Thank you.
All right, Mr. Hsiung, move on to the next question.
Please. So setting aside any biases by the prosecution as a whole.
Objection, Your Honors. I'm
Just
sorry,
clarifying
we have a
the question.
motion outside the presence of the jury we'd like to make at this time.
All right, ladies and gentlemen, there was some statement made by Mr. Hsiung or intimated that there was some prosecution bias. You are to ignore those statements. Okay, those are not in evidence. They're not relevant issues in this case. And the issues are what this witness knows and what he's done. So the remaining questions will be tailored to those issues. Mr. Hsiung, you may go ahead.
Thank you, Warren. Sergeant Clerk, are you aware of a criminal animal cruelty complaint shared by the defendant's organization on August 12th, 2021, approximately a month before the events at issue in this case? And specifically, a criminal animal cruelty report alleging, quote, neglect and mutilation of animals in foster farms.
I did hear something of that, but I don't have any actual knowledge of the specifics or anything like that. So no, I mean, I can't speak to anything specific regarding that.
Your Honor, may I approach the witness?
You may.
If you could just familiarize yourself with this document for a moment.
Can you identify what the document is?
The document is an August 12th, 2021 animal cruelty complaint. The names on the top are Bonnie Clapper and Erica Wilson, legal advisors for direct action.
Okay, did you have it marked?
I don't know if I'll be using this, I'll be asking for this to be admitted into evidence. I may, but for now, I just would like the witness to familiarize himself with the document so I can ask a few questions. If that's
Well, we need to have it marked nevertheless.
okay, we can mark it.
Yeah, go ahead. Sergeant, if you will give it to my clerk. This would be a defense,
I think it's defendant's one,
defense A.
or A, yeah.
Okay, defense 201. 100 series will be people, 200 series will be a defense.
Thank you, Your Honor. Let me know whenever you're done. So are you familiar with this document at all?
Just from looking at it for the past few seconds,
But you said you've heard something about a complaint of this sort.
I heard, yes, something along those lines, yes.
And I would direct you to the last page, just to see if this refreshes your memory.
Objection, Your Honor. Reading the report, is improper. The witness has stated he wasn't familiar with the report until just handed it.
I didn't read anything from the report, I just asked him if he could look at the last page so I could ask him
Yeah.
a question about it.
Well, if the question contains information on that document, it would be hearsay. It would also be beyond the scope of this witness's knowledge.
Let's see what the question is. I'm not sure what the question is. Ed?
So I just want to direct you to the last
Mr.
page.
Shaw, also, just, the foundation has not been laid yet, that the witness lacks, memory, lacks recollection in this case, so,
Yeah.
ask a question.
So tell me more about how you were familiar with an animal cruelty complaint filed by the defendant's organization.
I just heard it, I can't speak to when or how, when this whole incident took place, I did hear something along those lines. It may have been from the people that were there actually talking about it, I can't remember.
So you don't have a specific recollection.
No, and I don't know any specific facts.
But you recall this being an allegation of animal cruelty about foster farms.
Yes, I do recall that.
And does the last page of this document refresh your memory at all about the nature of the allegation?
It wouldn't refresh my memory because I don't know anything about the allegation, other than what I just spoke to you about.
Okay.
That there was an alleged animal cruelty complaint or something along those lines. That would be the extent of my knowledge.
Okay. So it's fair to say you did not investigate this allegation. You're aware of animal cruelty in August 2021?
I did not know.
Are you aware of anyone in your office investigating this allegation?
I am not.
Do you know if anyone in your office even read this complaint?
I don't know that anyone in my office actually received this complaint. So, no, I do not.
But you're aware of a complaint like this being filed, like you testified previously?
No, I'm not. I said I heard somebody speak of it. That doesn't mean I know that it was filed.
But a complaint like this were shared with the district attorney's office, can we agree? Objection.
Sustained.
I'm sorry.
Sustained.
If a complaint of this sort was shared with you, can we agree it would be something that you would want to investigate if there was a credible allegation of animal cruelty?
Yes.
And if there's a lack of investigation, that would be a legitimate concern.
I would say so, yes.
And you're not aware of any investigation as a result of this complaint.
I am not aware, no.
And again, you are the principal party responsible for investigating any crimes committed on or around Foster Farms property on September 28, 2021.
That's incorrect, no.
You were not investigating criminal
I was not
concerns.
the principal investigator, no.
Were you one of them?
For this specific case, yes.
Okay. And if you had knowledge of Foster Farms committing offenses that were against the penal laws of the state of California, you would have investigated that.
If there was an allegation I was aware of, yes, we would have.
I'm going to direct you to another issue. Are you aware of another animal cruelty complaint filed by the defendant's organization after the events of September 20, 2021 regarding animals being, quote, scalded alive?
I am not, no.
You have no recollection.
I'm not aware of it, no.
Your Honor, may I approach?
Your Honor, we're objecting. This report is allegedly occurring after the incident, would have no bearing on any issues before this case.
Your Honor, I think the report after the incident shows that the defendants had this sort of state of mind, that they will be.
One second. The objections is overruled. You may show, let's go ahead and mark it, and we can,
Thank you, Your Honor.
that'll be defense exhibit 202.
Just familiarizing myself with the document. We can look through it.
Okay.
Just let me know when you're done.
Yep, I'm good, yep.
Okay. Thank you, sir. Did you investigate any allegation of animals being, quote, scalded alive after the incident on September 28, 2021?
I was not aware of any incidents, so no, they were not investigated.
So you were not aware of anyone reporting that animals were being scalded alive after the incident on September 28, 2021?
I was not, no. Personally, I was not.
Are you aware of anyone in your office investigating allegations that animals were, quote, scalded alive?
I am not, no.
Are you aware of anyone in your office even reading complaints of allegations that animals were scalded alive at Foster Farms after the incident in September 28, 2021?
I'm not aware if anybody did or not, no, I wouldn't know.
I think you said this previously with respect to the August complaint, but can we agree that if there was an allegation that animals are being scalded alive, it would be a legitimate inquiry for you to look into?
Yes,
And if it were not looked into, it would be legitimate for citizens to be concerned that it was not being looked into?
yes, I can agree with that.
Thank you, Your Honor. No further questions.
Okay, redirect.
If you were assigned to investigate allegations against Foster Farms, would you do so diligently?
Yes.
No further questions.
Okay, may the witness speak soon.
Your Honor, I believe I still have an opportunity to do some recross, if I may.
Okay, recross with regard to what the people just said.
Thank you.
Go ahead and put the mic a little bit closer to you.
Sergeant, in response to, you said you would investigate any complaint that came to your attention regarding Foster Farms diligently, is that correct?
Yes.
But I think you also indicated that no complaints have come to your attention, correct?
Not that I'm aware, no.
Livingston is the primary, Foster Farms, their facility is in the city of Livingston, agreed?
That's correct.
The Livingston Police Department is the law enforcement agency that has primary jurisdiction over the area where Foster Farms is located, correct?
Correct.
So, based on your training and experience, any complaint regarding something that happens in the city of Livingston should make its way to the Livingston Police Department, correct?
I would say if it goes through the proper channels, yes, that would be the proper, proper procedure, yeah.
But at least as far as you're aware, you yourself have never investigated any complaints of misconduct against animals by anyone at Foster Farms, correct?
I have not, no.
Nor are you familiar with anyone from your department engaging in such an investigation, correct?
Correct.
That's all. Thank you, sir.
All right.
Your
Thank
Honor,
you,
can
sir.
I ask one follow-up question just based on the state's
You
redirect?
may.
You testified that if you're aware of an animal cruelty concern about Foster Farms, you would diligently investigate, correct? You just said that in response to the prosecution's question. Okay.
Yes.
You also testified that you knew there was a concern about animal cruelty, maybe not from a specific document you saw, but you knew there was a specific concern about animal cruelty at Foster Farms prior to September 28, 2021, correct? You'd heard this. You don't remember exactly where you heard it, but you said, because I heard it from somebody.
Not
but-
prior to that date, I'm saying, you asked if I had heard about this August 12th document that you provided me, and I believe I heard people speaking about that at the incident on September 28th, yes.
So you knew there was a concern about criminal animal cruelty at Foster Farms at some point over the course of your investigation?
Like, if that's what you want to call it, yeah.
Well, I didn't call it. I mean, you're calling it. You said that I was wrong.
I'm saying, people were saying, making allegations there, yes, or speaking about things, yes.
Okay. And did you follow up with that and do any investigation of those concerns about criminal animal cruelty?
I did not know.
Do you know of anyone in your office who did?
I don't know if they did, no.
Do you know if anyone in any office did?
I couldn't answer that, I don't know.
So you have no knowledge of anyone taking any action to investigate the criminal animal cruelty concern that you became aware of around September 28, 2021? Do you have knowledge of anyone? Anyone?
No, I don't.
No, okay. No further questions, thank you.
Okay.
Officer,
Speak soon.
do you have any knowledge of any entities such as American Humane evaluating Foster Farms to see if animal cruelty complaints are found?
Objection, Your Honor, this is outside the scope of direct. the third-party certification organization of Foster Farms was not within the scope of the direct, and I think it's outside the bounds of the redirect.
The question was, has anybody investigated Foster Farms and allegations of inhumane treatment? So my question is, has this officer heard of any other entities that may have done such an investigation?
Overruled. You may answer the question.
I've not, no.
Okay.
I don't have any personal knowledge of that.
So your testimony in this case and your knowledge of this case is as to the incident where these 2 chickens were taken, and that's what it's limited to?
Yes.
Thank you.
All right. Okay. If witness speaks to you. Mr. Atwell?
The witness is excused, Your Honor.
All right. Thank you, officer. You are excused and you are released from this meeting. People may call the next witness.
Your Honor, if I could just put on the record, if we could have the right to possibly.
Counsel and the defendant are present. Mr. Little or Mr. Fairway, Mr. Hsiung, I understand you have a motion to make.
Yeah, Your Honor, I would move for a judgment of acquittal, and when your Honor deems it appropriate, I can make some argument by that I imagine my co-defendant would join this motion. But I'll just say to start that I am moving for a judgment of acquittal.
Good. You want to go ahead and argue? Go ahead and argue.
Yeah, I'm happy, Your Honor. You know, I think, Your Honor, the key element that has not been demonstrated, even to a modicum of evidence, is if you look at the Calcrim instruction, they have to prove beyond a reasonable doubt the defendant took the property and intended to deprive the owner of it permanently. There's been zero evidence about what happened to these chickens after that 45-second video. No evidence about the intentions of the defendants about what happened to the chickens after that 45-second video. And if we're looking just at the evidence presented in this courtroom, all the jury knows is the chicken was taken out of the truck. That's it. And they didn't ask a single question of any of the witnesses as to whether the chickens were returned. Whether the defendants asked if the chickens needed to be returned after veterinary care was provided. And while it might be the case that they didn't plan to give the chickens back, it is an essential element of their case. They have to prove beyond a reasonable doubt. And I don't think there's even a modicum of evidence, much less substantial evidence, that a reasonable jury can conclude these chickens were permanently deprived from their owner. This is the prosecution's burden. It was not met in this case, so respectfully, primarily on the basis of that element, I would argue that a motion for judgment of acquittal should be granted. Secondarily, I think the only value evidence that was presented was in cross, and it was all hearsay. It was not evidence that the prosecution is entitled to rely on. But I understand that's probably a weaker argument, because just by virtue of the fact this is a chicken in a truck, there's an argument that there's substantial evidence. So my main argument is just that there was zero evidence about what happened to these chickens after they were removed. And that is an essential part of the state's burden of proof.
All right. Mr. Little, you want to add anything to that?
Thank you, Your Honor. Yes, briefly. Obviously, the instruction at issue here is Calcrim number 1800 and the law related to Penal Code section 484. And with respect to the first element, the defendant took possession of property owned by someone else. And if you read the notes to the instruction, it just can't be anyone. There has to be a specific owner shown, because otherwise there would be no way to present the affirmative defense of consent. So essentially, there had to be some evidence shown for this case to reach the jury that the chickens on board that truck were owned by Foster Farms, and there's been actually zero evidence of that. All the jury could do is assume that in the absence of any evidence, which is not the standard. There's been no evidence by anyone with any knowledge of the facts and circumstances that those chickens were owned. I mean, I can think of other possibilities that they were consigned by someone, that there was some other arrangement other than ownership. There's simply no evidence of ownership. The jury is being asked 100% to just assume that the alleged victim, Foster Farms, owned those chickens in the absence of any evidence, which supports a motion for a judgment of acquittal. Furthermore, there's been, and this is the third element, would be the fifth element, and it only really applies to cases such as this where value is disputed. But there's been no evidence that has been admitted as substantive evidence for the truth of the matter regarding the value of these birds. Specifically, there was evidence on cross that was brought out regarding what, if anything, the officer was told, but that was not, and we objected to that as being hearsay. It was allowed, but I'm assuming not for the truth of the matter, but just to show what the officer believed when he wrote his report. So there's no substantive evidence as to value. So once again, the jury is being asked to assume a value in the absence of any substantive evidence. So for both of those grounds, we would contend that the motion for judgment of acquittal should be granted and that the defendant should be discharged.
I would just join in the reasoning on the
All right.
Your Honor.
Okay, Mr. Attwell, Mr. Colby.
Your Honor, I'll take these in order. First, the chickens being owned by Foster Farms. The people's first witness testified he was a driver for Foster Farms, carries chickens regularly, picks them up at the farm, delivers them to Foster Farms, and that no one is allowed to take those chickens. That is surely enough evidence to present this case to the jury that Foster Farms actually owned these chickens. Moving on to whether or not they actually took property of another, intending them to deprive. People's Exhibit 101 clearly shows the actions of both of these defendants, grabbing chickens out of the back of a truck, running into a private vehicle, and getting in that vehicle. That is for purposes of the motion under 1118, that is clearly sufficient to establish that they took that property with that intent, Your Honor. And again, we're talking about intent, not what they actually did, but what they intended to do. And it's clear from the actions on the video that's what they intended to do. Finally, as to value, the defense is correct. They did solicit evidence of value. Specifically, as the sergeant on the stand said the chickens were worth $20 each, and he was given that information by Foster Farms. That questioning was not objected to. It was not asked to be admitted in a limited fashion in any way, nor could the proponent of that evidence actually do that if there's no objection by the other side. The defense brought it in. That's sufficient. This motion should fail, Your Honor.
Okay. Anything else?
Your Honor, I would just add that the prosecution incorrectly read the instruction in element 3 is not that the defendant took the property and intended to deprive the owner of it, but intended to deprive the owner of it permanently, right? And there was not a word of testimony throughout this entire trial so far as to what happened to the chickens after that 45-second time period. No jury could reasonably conclude, just based on the evidence presented in this courtroom, that there was a permanent deprivation, or alternatively, an intent to deprive an owner of its possession for so extended a period of time that the owner would be deprived of a major portion of the value of that property, because we didn't talk about the chickens at all after they left that video. All we heard was that, for all we know, they took chickens out of a truck and they gave them back to Foster Farms. There's all sorts of inferences that could have been made, but there was no evidence that would help a jury conclude one way or another whether the chickens were permanently deprived of their proper owner. I think, prosecution, correct me if I'm wrong, but I don't see a word about what happened to the chickens after that 45-second video. I think that's sufficient on the instruction to make a ruling that there's not substantial evidence of permanent deprivation or so extended a period of deprivation that the property's enjoyment or value was lost to the owner.
Okay.
Once again, Your Honor, counsel misses the key word, intent. What was the defendant's intent? In this case, there is a video showing these defendants going onto a truck, a commercial truck, taking property that clearly is identified as belonging to Foster Farms by that video, taking that and absconding with that and fleeing, matter of fact, running back to their vehicle, getting in the backseat of a vehicle, clearly showing the property. To say that that's not sufficient evidence for a jury to conclude that their intent was to deprive Foster Farms permanently or for such an extended period of time that they lose substantial value would be inappropriate. This is something where intent can be inferred by actions, and that's the key word here is intent. So the burden's been met, the case should be presented to the jury.
The only thing I will add in summation, Your Honor, is clearly the driver did not profess to have any knowledge as to the owner of those chickens. He only knows that he drives a truck owned by Foster Farms and that he was taking them somewhere. As to whose chickens they were, there was zero evidence as to that. Submit.
All right. All right. I've heard the arguments of counsel. The motion is denied. The court, the evidence produced in terms of ownership, the driver indicated that he's employed by Foster Farms on the day in question. He was driving Foster Farms' vehicle. He went to a Foster Farms ranch and picked up the load, took it to on the way to Foster Farms facility. And so I think the jury can infer from sufficient evidence presented, there's sufficient evidence for the jury to infer of ownership. In terms of intent, I think the video, again, the jury can read from that, and there's sufficient for the jury to infer whether there's intent to deprive the owners of the 2 chickens for an extended period of time. I would also add that item number 4 says the defendant moved the property even a small distance and kept it for a period of time, however brief, and that in itself can also be sufficient evidence of intent as well. That the movement of the chickens and the manner in which they did it, which is that they opened the cage door while the vehicle was stopped, and the video seems not in a casual, calm manner, but they were opened quickly, rushed to their vehicle, and appeared the vehicle was driving away. So those would be sufficient evidence for the jury to make the decision. In terms of value, the value was clearly solicited or elicited by the defense. So the value, for what it's worth, there is evidence of value. For those reasons, the motion is denied. All right, let's go to the next motion. There was an issue regarding the witnesses.
No, Your Honor, there are, I think, 2 things of evidence that we're going to introduce through our first witness that it's my understanding that they'll probably have some objections, and I figured it'd be better just to hash them out now. The first is the legal opinion from Professor Hadar Avaram, in which the defendants relied upon. When we discussed that in the motion in lim, the prosecution had indicated that they would probably have some sort of hearsay objection, so I figured might as well just address it now rather in the middle of my direct.
The question is, who is counsel's first witness? Is it his client?
It'd be Ms. Santurio.
Okay.
That, obviously, that changes the analysis.
It does, because it's not for the truth of the matter, it's for state of mind.
Now, we still are objecting to the mistake of law defense, and we can bring that up. I believe with the defendant, though, if the questions are limited to what she was aware of that opinion and things relating to that opinion that she was aware of, maybe other people's opinions that are different, that would open the door for all those questions. So I think that's a different issue, but we do need to figure out whether or not mistake of law is actually going to be a viable defense. I know the court has tentatively believed it would be, but again, the problem with that letter is it details an assertion that somebody can act in a way that violates the law but have an affirmative defense. Mistake of law defense only applies if there's substantial evidence to show that the intent was negated. And so that's the fundamental problem we have here, is that the intent to take these chickens and permanently deprive or deprive for a substantial period of time the chickens from foster farms, if they believe they have an affirmative defense, doesn't rise to the level of mistake of law, because it does not deal with the intent, only with whether or not they believe they have the defense of necessity. Now, I understand this court has ruled the defense of necessity does not apply, but this is also sort of a backdoor way to argue necessity without arguing it. We believe that the mistake of law defense should not be allowed.
Well, let me ask this, Mr. Caraway, are you going to introduce the letter as evidence?
Yes, yes.
That's your intent? Is there any objection to the letter coming in? That would be, it seems to me that would be entirely hearsay. I think your client can testify that she read the letter, she relied on the letter. That goes to the issue of her state of mind. But to introduce that, I'm not sure what the purpose of that would be.
Agreed, Your Honor. There's a Sanchez issue with the admission of a letter of somebody who purports to be a member of a bar somewhere, if admitted as evidence wholesale. If mistake of law isn't the defense the court is going to allow, the only question would be, did the defendants rely on that and have reason to rely on that? That's why the letter itself should not be introduced as evidence.
And Your Honor, I guess my response is really twofold. First, as the court sort of picked up on fairly immediately, it's not admitted for the truth of the matter. It's admitted for the effect on the listener. And that's a valid hearsay exception of the litany of cases, Heiselgesser versus Citibank, which is a 2008 California Appellate Opinion, which is B1999-029, is the site. Additionally, People versus Ramirez, and Westall just logged me out, so I'll come back to that site. But I don't think it's really beyond question that effect on the listener is a valid hearsay exception. I think the second component, however, is I would presume the prosecution is going to challenge the defendant's good faith reliance on that letter. So certainly the jury should be entitled to actually see the source of the information for which the defendants were relying on. And in many ways, it's almost kind of like the same logic for the preference for written documents, things like that. Certainly the court can entertain a limiting instruction that this is not for the truth of the matter asserted, this is just the actual document that they were relying on. But I think to simply allow them to say, I read a letter, without explaining to the juror just exactly what that letter is, how thorough that letter is, the other information in that letter, the UC Hastings letterhead, that allowed the defendants to reasonably rely upon this, is critical for the jury to determine, because the main question for mistake of law isn't whether they were correct, it's whether they had a good faith belief to rely on that letter. And how else best can you determine if they had a good faith belief to rely on that letter without actually seeing the letter? And certainly the court can entertain instructions to appropriately instruct the jury how to assess that letter. But I think that would just simply be hiding a lot of the most pertinent evidence related to their state of mind, which is what they knew, what they were told, what they believed, that informed their opinion that what they were doing under the circumstances would be lawfully permitted as outlined in the letter.
All right.
Your Honor, if I could just add something too on behalf of Ms. Paul, I will join in all the arguments of co-counsel, but I do have the quote from People versus Ramirez: evidence of an out-of-court statement may be admitted for the non-hearsay purpose of showing its effect on the listener, so long as that effect is relevant to an issue in dispute. I think everyone agrees that's relevant to the issue in dispute, the mistake of law. And this is a non-hearsay purpose that specifically under People versus Ramirez is allowed under California law. I'd also just add, Sanchez is a case that relies on opinions about hearsay evidence. We're arguing this is not hearsay evidence because it's used for a different purpose, not for the truth of the matter asserted, but because under Ramirez, the effect on the listener is evidence that is relevant to the inquiry of what was on a particular listener's state of mind. So we're not using this for hearsay. Sanchez is just inapt. It's inappropriate to invoke Sanchez in a case like this because we're not trying to use this expert's opinion for any hearsay purpose. It's for a non-hearsay purpose. Thank you.
So, Your Honor, Sanchez deals with the introduction of statements by an expert as to an expert opinion upon which his or her opinion was based. Statements that are case specific. It doesn't get much closer than that. The letter of defense counsel seeks to introduce opinions of somebody purported to be an expert as to their opinions that would affect material issues in this case that is case specific to this case. The whole point of Sanchez was that to both the defense and the prosecution, it is actually runs afoul of due process when expert opinions are allowed in and the opponent doesn't have the opportunity to cross-examine that expert. Now, if they're going to call him as a witness, that would mitigate this issue. That said, though, what it boils down to is mistake of law going to be allowed? Again, we profess it shouldn't. And they can cite that they relied on a letter. They can cite in general, under Sanchez it says you can relay in general terms what an opinion is based off of. The only difference is we're talking about a defendant's opinion as to whether or not they held a belief in some sort of mistaken belief versus an expert's opinion, but lay opinion and expert opinion are treated the same in this regard. So did they see a letter? Did it appear relatively thorough? Did it have a letterhead purporting to be something that you might want to rely on? Those are all questions that can be asked. But introducing the letter itself and the specifics of this without it getting the opportunity to cross-examine the person who wrote that letter is an issue. So our objection still stands in that regard.
All right. The defense may examine their client regarding their reliance on the letter, the circumstances and the specifics forming that reliance, but the letter is not admitted because admitting the letter would be admitting a hearsay statement, although the hearsay statement can be used for the purpose of reliance, the jury would not be able to distinguish the difference between a piece of documentary evidence that is admitted for a non-hearsay purposes as opposed to something that is hearsay. And so the court would give you wide latitude to discuss that, but the court would not permit admission of that letter.
And just to sort of clarify the record, first the case I cited, Heisel Gesser versus Citibank, the Westlaw site is 08 Westlaw 5253952. Admittedly, it's Second District Court of Appeals unpublished, but what I thought was relevant for its persuasive value is that applied the effect on listener hearsay exception actually from a letter from an attorney for the defendants in that case. And I guess my concern is that we're going to show the defendants the letter, we're going to ask them questions about it, and we're not going to admit it. That's certainly going to invite the jury to sort of speculate as to why they're not getting that letter. And if the prosecution is going to seek to impeach or attack the credibility of that letter, of that advice, or their good faith reliance, I would posit that that certainly opens the door for us to introduce that document.
Well, you know, it depends on where prosecution goes. I agree if the people then says, well, you know, show me the letter. Or if you relied on the letter, then, you know, where is the letter? Or something like that, that would open the door.
Oh, I think certainly a line of questioning that sort of insinuates that their reliance on this letter was not in good faith, was not diligent, was not reasonable. You know, I think that all begs the question, especially in the juror's mind, well, let's just see the letter for ourselves. And I understand the court's concern about how the jurors would view the letter. And I think the best way to address that concern while preserving the defendant's rights under the state and federal constitution to present a defense and have effective assistance of counsel would be to offer a limiting instruction, instructing the jury, and jurors are presumed to follow the court's instructions, but instructing the juror that you are only to rely on this letter as it relates to the effect it had on the defendants. And I think that would comprehensively eliminate the court's concern that they would over-rely on this letter as a de facto secondary court instruction. But I think the concern I have is that we're effectively presenting 90% of the evidence relevant to the mistake of law defense, and we're not being entitled to present the best evidence. And I think this is really a best evidence issue as well. We have the actual writing. And you know, I think under the best evidence rule, I mean, it's preferred to actually have the document that people are discussing introduced as evidence as opposed to having people discuss them. And that's so the trier of fact can actually evaluate the document and determine whether or not it was reasonable to rely upon it, particularly with the arguments that the prosecution has already made that the letter was, you know, some years ago, I think 3 years before the alleged offense and things like that. So I think with a limiting instruction, the court's concerns will be wholly addressed.
How is this situation any different from a witness expert in Sanchez situation, a witness expert relying on hearsay evidence, which they're permitted to do as the basis of their opinion, and yet those hearsay evidence of themselves are not introduced? How is this any different?
Well, the difference is how we're introducing it. So the Sanchez problem is you have a hearsay statement in which the expert is substantively relying on what is being said. So for instance, an expert conclusion that is out of court, for instance. The testifying expert would be relying upon the substance. While we're introducing this letter for the purposes of mistake of law, not for the substance. We're not introducing this letter to say the necessity defense applies. We are introducing this letter to say an attorney told them that under certain circumstances that they could be lawfully entitled to rescue animals. And the thrust of it is that they reasonably relied on this document. And it's not a sort of substitute for a conclusion. And the court can certainly instruct the juror to, with respect to a necessity defense, is rely on the instructions that I give you.
Well, the conclusion your client's drawing is the reliance, right?
And that's the difference.
And so you can testify to all of that, she can testify to all of that, but why does the letter why does the letter come in?
Because it is the best evidence of the information in which the defendants read and comprehensively relied upon. You know, we're not just summarizing what a letter said. We can, in fact, show the jury this is exactly what they read, and the juror can evaluate, is the information in this letter going to be sufficient? Because the other problem is, without introducing the letter, the jurors could be more likely to simply discredit the defendant's testimony about what they read or what they believed in the letter. And I think it would sort of result in an opportunity where we want to actually present the source material, and our failure to do so permits speculation or a further interrogation of their credibility on, well, what did this letter actually say? Does this letter actually exist? I mean, they said they did, but we can reject their credibility. You know, it is the same as introducing sort of a photo or an exhibit to further draw that link, that this evidence in fact exists and you can rely on it, and it's not just you can disbelieve the defendants because we didn't actually show the proof. Granted, we don't have a burden, but I think the jury's going to think that. The jury's going to be like, we talked all about this letter. Certainly, you know, they're going to be reading, you know, they're going to be referencing it and things like that. I'm going to be describing it. You know, what's on the letterhead? And the jury's going to be wondering, well, why don't we just get to see this letter? And because they don't get to see this letter, you know, that certainly raises the inference that, you know, is there something missing? Is there something that the defense didn't want us to know? When I can't really see the prejudice to the prosecution, and particularly with a limiting instruction about the appropriate way the jurors can assess this evidence. And again, this is the best evidence of the substance of the information for which the defendants relied upon.
All right.
So the court would have,
Mr. Coates.
the court would have to, shows you the slippery slope that we go down. If the court did introduce the letter, not only would there be a Sanchez problem, but then, as the court has ruled, necessity is not a defense here. The letter indicates necessity is a defense. The court would have to specifically instruct the jury that the letter is wrong. This is that slippery slope we get down when we have a letter that's introduced to support an opinion. This is precisely why Sanchez changed the legal landscape, and quite frankly, good on Sanchez. It was good that they said you can't bring in case-specific hearsay to prove your point in court. So what it boils down to is that letter creates the issue, creates confusion of the issues. In addition to violating Sanchez, in addition to violating hearsay, there are quite a few issues with it. Again, defense counsel can ask, did you rely on this letter? Who does it appear to be from? They can give the attorney name, they can talk about the letterhead, they can talk about that it was greatly detailed, and we're not going to dispute that the letter exists. And we're not going to dispute the letter purports to say they could in fact do this and they had a legal defense. I'm going to go off on my tangent again and talk about how mistake of law shouldn't be allowed because the letter refers to a defense as opposed to intent. But for all those reasons, Your Honor, the court's ruling should stand that the letter is not admissible in and of itself.
Your Honor, just briefly on behalf of Ms. Paul, I obviously join in co-counsel's concern and would like the letter introduced. In the absence of that as an alternative, just an instruction to the jury not to draw any inferences as to why certain documents are allowed in and not allowed in would be a good corrective instruction if the jury were to make certain inferences about why they're not able to see a document like this letter or even some of the other legal opinions we've had witnesses examine in this case. So, of course, I would join in co-counsel's request to have the letter introduced as evidence, but if not, I think at a minimum we should give the jury an instruction not to draw any inferences about why they're not entitled to see certain documents.
Well, the court certainly would do that. You know, it goes both ways. But there's an additional concern about, you know, about the letter coming in is that, you know, the court certainly doesn't want the jury to read the letter and say this is the state of the law. I don't even know if that's the state of the law. But we're getting now into all kinds of tangential legal issues that's not before this court. So, you know, that's, yeah, that the court's decision will stand. Good.
And Judge, the second sort of category of evidence is, and we discussed this so briefly in motions in limb, which are 3 videos of the post-rescue of the birds, and the prosecution had raised an objection, I believe on hearsay grounds and the lack of transcript. You know, what we had gone ahead and done.
I'm sorry, if I can interrupt counsel, if his intention is to play the videos without the sound, we are agreeing to that and withdrawing the objection if that's going to be the issue.
That's great, and so we'll introduce that. We'll actually just publish it later, but I
Yeah.
think that's where it's at. And then
I'm sorry, this is a different video, right? Not the same one we already played, it's a different video.
it's a different one, yes.
Okay, all right.
And just everyone knows, I put them on a USB drive.
Okay.
And Ms. Santurio reviewed them, confirm, initial them.
Okay.
Now, the final aspect too is I just want to sort of make sure it's clear. The court had ruled that the necropsy was admissible. The prosecution had stipulated with respect to the custodian record, so we released her from our sub.
Okay.
Just so there are no surprises, I just intend to just kind of introduce that through Ms. Santurio, just to have it come in through a witness. I would, understanding that there's a stipulation on the foundation, I would just go ahead and ask for a little bit of latitude just to go ahead and get that into evidence. I'm not substantively asking about the substance, but I figured that probably makes more sense than just having it up
Sure.
here as part of the evidence.
All right, yeah, is that true?